Good morning. Good morning. Good morning. Glad to see you all here. I am grateful you were all able to come. Several of you are watching at home, so you will see me sometime later. The attendance is open. If you sign in now, please do it. If you're watching at home and you email me, I will mark you excused. There'll be no absences and everyone will be on the same page. Okay? Any questions from last class about the New Deal cases, about the Warren Court cases, the Katzenbach and Ollie's Barbecue? Any questions about the Progressive Era cases? Nothing? Okay. Let's try a question, a poll question for today. Let's see how you guys do in this one. So, oops, there it is. Here's your question. All right, so your question's this. In Wickard versus Filburn, right, the Supreme Court upheld the regulations under the Agricultural Adjustment Act solely on the basis of the Commerce Clause. True or false? A is true, B is false. Okay, that's your question. I'll give you another 20 seconds or so. This is a weird configuration. I don't like this classroom. It's very, very condensed, isn't it? Like it's really close. I've never taught in this room before. Have you ever been in this room? No. Our room wasn't taken. They're having some for admissions event this weekend, so the entire fourth floor is occupied. You probably saw them mulling around downstairs. Yes. One person in the elevator said, "Are we gonna have fun?" I'm like, "You have a flash." She's like, "You're lying to me." And they said, "Are you a student?" I'm like, "No, I'm a professor. You'll probably have me in the spring." And they start awkward laughing. Still happens. Okay. All right. I have no idea how we're going to do the attendance thing, so I'm just going to start here and we'll move our way around. We'll go back to north. So, Clint, what did you put here?
Put true.
Okay. Why'd you put true?
Because that's the correct answer. They chose, they said in Wicker that they used the agricultural commerce clause. He was growing wheat. Everything that their justified decision was on him growing wheat. Had absolutely nothing to do with any of the other clauses. They didn't need the necessary clause because his growing of wheat fell within the bounds of commerce. It substantially affected the overall economics of the wheat growing in the United States because he was growing it for his home use. Because he was growing it, he didn't have to buy it, and he just kept going through the layers of influence.
All right, so Abdullah, explain to me what the substantial effects test is. How does the substantial effects test work? What is the substantial effects? Clinton said a minute, but I want to restate it for me, please.
I was actually paying for the subscription. It ran out, so I didn't hear what he said.
You don't need that right now. I'm asking you. Substantial effects test.
No, I'm saying I didn't hear what he said.
It doesn't matter. What's the substantial effects test?
I don't know.
Then just say that.
Okay. Yeah.
Alan, what's a substantial effects test?
From what I remember, if it's substantially.
If what? What substantially?
If the activity in question, which is in this case him growing his own wheat, affects the overall market, then they have the power to regulate it.
Why? Why does Congress have the power to grow locally grown wheat that will never leave a farm? What gives Congress the power to do that?
Because overall, within the Commerce Clause, it affects the commerce of the nation.
Okay, good. And you said affects, but the word substantially affects. I'm just going to modify your answer somewhat. So we have here a provision, right? It says, Congress will have the power to regulate commerce with foreign nations and among the several states. So McKinney, is the actual act of growing wheat on your farm that will never leave your farm commerce among the several states?
Well, the reason that they decided they wanted to regulate hemp growing from personal weed is because the end game for Congress was to artificially inflate the price of wheat on a national level.
Good.
So,
But just the actual act of growing the wheat by itself, is that by itself commerce among the several states?
it was in this context because
It was or wasn't?
it was because having that wheat is wheat on the market. Whether it was
No, you're giving me the next step. I just want to just by itself, is growing wheat by itself commerce among the several states? Just that alone.
No.
Okay, everyone agree with that, right? Yes, and Michelle?
We're not able to, we can hear you, but it's hard for us to hear because I think the fan is.
Oh, I'm sorry. I don't know how to fix it. If you want to move closer or whatever, or you guys just got to yell.
Okay.
Yeah, if you can't hear it, put your hand up. So what McKinney said, I think, is exactly correct. You hear me, right?
Yes.
I'm loud. What McKinney said is the actual act of growing the wheat, that is not commerce among the several states. Okay? What is commerce among the several states is their ability to keep prices high by keeping the supply low. The difficulty, though, and this is why when I phrased the question the way I did, I use the word solely. Okay? I use the word solely. Kenny, can Congress reach local economic activity by itself solely on the basis of the Commerce Clause?
Yes,
Can they? Why?
if it affects,
But the actual commerce itself is not among the several states. You see where I'm going with this? Sam, you see where I'm going with this?
I think so.
All right, so carry on. Where am I going with this?
Are you like trying to refer to the aggregation principle?
And what allows the aggregation principle is the Commerce Clause?
Yes, I believe so, right?
By itself, though. No.
Oh, okay. I mean, I guess that would be, the aggregation principle could be the necessary and proper part.
Now we're on the right track here.
Yeah.
The court is very fuzzy on this. Okay? The court is very fuzzy on this in Whitney. Indeed, the court is very fuzzy on this in Lopez as well. Right? Let's take an easy case. With Hearts of Atlanta Motel, they were attracting out-of-state customers to stay at the hotel, right? That's easy. With the Ollie's Barbecue, Katzenbach, they were buying food, or a little matchbox, right? From out of state. That's easy. But Wickard is the hardest of them all because it was literally wheat that would never, ever, ever, ever leave the state. And if you didn't get it by reading Wickard, reading Gonzales or Raich, it makes more sense, especially Scalia's concurring opinion. The aggregation principle, and just listen to me very carefully, right? The substantial effects test, aggregation, is not based on the Commerce Clause by itself. It's Commerce Clause and Necessary and Proper Clause. Or stating a little bit differently, the Necessary and Proper Clause, which we've read a dozen times, right? Congress can make, let me close the stupid boxes. Everything's off on the screen. Okay. The Necessary and Proper Clause allows Congress to make laws that are necessary and proper for carrying into execution the foregoing powers. And the foregoing power, again, is commerce. It's always commerce, right? So Jackson's opinion is a little bit fuzzy on this. But what they're effectively saying is what gets you to substantial effects, what allows you to aggregate everything is necessary and proper. It's through the Necessary and Proper Clause that Congress can reach the locally grown wheat. It's through the Necessary and Proper Clause that they can reach locally grown marijuana in the Raich case. Okay? They don't need Necessary and Proper in the Ollie's Barbecue case or the Hearts of Atlanta case. They just don't need it because they actually have stuff moving across state lines. But to get to purely local activity, you need Necessary and Proper. Right? So the answer to this question, and I'll give you a hint of how I phrase these questions. Right? I put the word solely in there, right? If I put the word solely in there, it's asking for an absolute, right? It's not like wishy-washy, right? So the answer is false, okay? Okay, I tripped most of you up, which is exactly what I expected. You need necessary and proper to get the substantial effects. Jackson, again, remember he had various draft opinions on this? He fuzzed this a little bit, so I'm not mad at you that you got this wrong. I'm actually not mad at you at all. Most people don't grasp this. You need to read Scalia's opinion in Raich, which actually explains it much better, right? You have this nationwide scheme to keep prices high and keep supply low. Congress can do that. Because the local wheat is part of that nationwide scheme, necessary and proper lets you regulate that locally grown wheat. Use marijuana, for example. Because Congress has a sophisticated scheme of regulating controlled substances nationwide, under necessary and proper, they can reach the locally grown marijuana. They can reach it. That's Scalia's opinion in Raich. We'll get there later. But I wanted to use this to bridge last week with Wickard to our class today on Raich. Everyone get that point. This is the hardest aspect of this entire topic. People do not get necessary and proper. They don't get it because they think it's this, whatever, Stanley, McCulloch, Mellon. All of these Commerce Clause cases involve necessary and proper. Whether they say it or not, they do. In fact, when we get to Lopez, I'm going to criticize Chief Justice Rehnquist, who doesn't really talk about necessary and proper. He mentions it really briefly in passing. Like, I think Scalia made him insert that, if I had to guess. But he mentioned it really briefly. When you read the Obamacare decision for Tuesday, right? For Tuesday, Roberts nails it. The Roberts opinion will explain necessary and proper better than anything else you read this semester. Then he'll break my heart. He does it every term. But the necessary and proper clause, he explains it clean. All right. So everyone okay with this question? Ask me, stop me to it. Is that Gabriel?
Yeah.
Yes, sir.
So just to confirm, you said that it's wrong because the word solely.
Yes, sir.
Okay.
Yeah. It's necessary and proper to execute foregoing powers, and foregoing powers is you said commerce? So they hear you in the back?
Yeah,
There you go. You got it? Okay. Other questions on this one? Yes, sir. Clem.
So last semester you said the answer to that was true.
Did I?
Yeah.
Wow.
That's why the exact same question, you said that was true, and you gave conflicting analysis. And so, I'm not to call you out, is that because it is based upon, so your answers here, and this is just from my understanding on the exam side, let's say, because you made a case that it's true, now you made a case that it's false. So, from what you're telling us is that it all is based on the analysis and how you look at it. It doesn't, the answer is never going to be
Well, that's
definite.
true. That's true. I don't remember what I said last year, but I'll go back and check. But the answer here, right, if you read Scalia's opinion Raich, right, he recognizes that Wickard is only based on necessary and proper. It can't be by itself.
Okay.
Yeah.
I mean,
You guys remember I said better than I did.
Yeah, I mean, well, so the reason I chose true, and then I gave you the analysis that you used last semester, and then, which is fine. I mean, I agree with your analysis.
Which one's better?
Actually, I like this. I like today's analysis better.
It
was more in line with what I thought when I watched your video from last semester.
So maybe I got better as a teacher. So this actually is probably going to happen. One of the downsides for recording lectures is I often learn from you, and often I think of things differently. And it's possible. Did anyone challenge me this last year?
No.
No one challenged me. They
Not
were not on
on the
point.
video.
Not on point. Huh. That's fun.
I would have
I think
challenged you
you
last
said in
year.
class last time you don't even need necessary and proper because I wrote that down like Commerce Clause was enough and let's move on.
Yeah, I think I was wrong last year.
No, this is last class.
Last
I
semester,
actually
yeah.
amended it.
Yeah. Huh.
And I also have a question. Was
Yeah,
it the
yeah.
act of growing the wheat at all or the fact that he did
Well,
21 acres of it?
Well, the act of growing the wheat was an economic activity, right?
It was. But was it the volume that they had an issue with? Because if he had just done 1 acre, which
Well,
was
that comes up in Raich, though, right?
Yeah.
That comes up in Raich, where O'Connor makes a very big point about the fact that the Congress only regulated a small amount. To which the majority replied, Congress could have gone further, that they didn't, it's irrelevant, right? That's what the majority opinion by Stevens replies. Okay. So I think the quantity didn't really matter for Justice Jackson's opinion. If they wanted to go after, what O'Connor say, an herb garden, right? The majority said they probably could have done that. But Congress said they couldn't have done it. But I think under necessary and proper with the Raich majority, they could have. I go back and see what I said last year. That's actually fascinating. Huh.
I thought you did it on purpose just to set me up, but I was like, I went back to make sure it's the same question as
No, I'd
everything.
never do that. I would never set you up. I can't see your name tag. Oh, Scott, you gotta use a bigger marker.
It's just with pen, I forgot.
Yeah, Scott, what's your question?
So this one, they noted in the book that Jackson had 3 drafts and was going with it. So it made note, I'm thinking something must be there. Is that just because to stress the importance of what was going on, or were there outside forces with that?
Right, so what's going on with Jackson is that they were trying to decide how far to go. They're trying to decide how far to go. And the opinion that they've ultimately wound up with went pretty far. The initial versions of it would have been much more narrow. They would have said, well, maybe we can send it back down to find, was there actually weed being shipped into interstate commerce, right? They could have resolved it more narrowly. They decided not to. The opinion Jackson only picked, though, put substantial effects on a very broad target. I think I know what I did last year. I was probably thinking of Jackson's opinion, not Scalia's opinion. Yeah. I don't like, I'll just pause on this for a minute. I don't like multiple choice questions because they're often very, very broad, and depending which angle you, I think what I did last year, I answered it from Jackson, this year I answered from Scalia, from Raich. I think that's what happened. This is why I never give a multiple choice question exam, ever, because I think it's unfair, especially in ConLaw. So if I were to ask this on the exam, I would probably take either answer, to your point. Which I think depending which angle you put it on, I think I just put it from different perspectives.
I didn't mean to impeach you, but I mean, I
No,
like
you're
this.
right.
I agree.
Right.
I
You
agree
agree with me
more
today?
with today's opinion.
Good.
When I watched the video, I agreed with what you were going to say. I didn't say your opinion today because what was based on the video.
That's right.
Which told me that my opinion, I should have just went with my opinion.
So you were actually right, what you actually thought.
Well, I would have been right. I would have been wrong last year, right this year.
Okay, that's what counts. No, but I think, if I remember correctly what happened, I probably was thinking about Jackson when I did this question last year. Because he hasn't really mentioned. But he had to get to it, in light of the later cases. Okay. Yeah, Jonathan.
Well, if I use any enumerated power, shouldn't I always tie a necessary and proper to it in any argument, or is that?
Well, in Katzenbach and Hearts of Atlanta, you don't really need necessary and proper, though, right? Because there you actually had food products being shipped across state lines, and you actually had transient visitors from other states. Make sense?
Yeah, but wouldn't it make my argument more solid if I did?
Oh, you can always no bootstrap means? You can always add in necessary and proper to make it even stronger. Make sense? Okay.
So the substantial effects test falls underneath the necessary and proper. You cannot have a Commerce Clause based directly on substantial effects. You have to tie in necessary and proper based on the Scalia opinion.
Right. So this is actually one towards Lopez, right? If there's actually some interstate commerce instrumentalities, right, the channels, then you're fine. But when he's got to watch my lectures closely. We'll get there in a minute. But when you need the substantial effects test, you need to go to necessary and proper.
Okay.
And this is Rehnquist. He screws this up. I think I said this last year in class. Rehnquist doesn't hit this very carefully. Okay. One of the fun parts about having my lectures recorded is occasionally I'll make a joke one year and I forget to make it the next year. So you didn't make that good joke. You didn't tell that story. So I'm sure people will call me on this. All right. How are we doing? Good? Yeah, Gabriel.
So just to piggyback what you said, if you would have asked in part of the planter instead of wicker, or the bark wicker thing, would that actually...
Sorry, what did you...
So in the question right there, instead of having wicker, if you would have the motel case...
Which case?
The Heart of Atlanta.
Oh, Heart of Atlanta. You don't need necessary and proper
Right.
Heart of Atlanta. Yeah.
Right, so that would be true.
Yeah, I think that's true for Heart of Atlanta. I think that's right. Good question. All right.
So no necessary and proper enhancement?
I don't think so. I don't think so. Yeah, David?
So I just noticed what you said, I mean, about the answer last year, and you said it's an intrastate activity and has a substantial effect on intrastate commerce, and Congress can regulate it. At issue in this case was the growing wheat, which is economic activity, and again, it's intrastate. And the Congress can regulate it when it has a substantial effect on intrastate commerce, again, but itself alone may not, but the aggregate substantial effect altogether with it can have that substantial effect.
Yeah, that's correct. Yeah, yeah, the substantial effect, we'll get to Lopez in a bit, but substantial effect, you need necessary proper to get there. I think I'm right. Let's do the spending clause, okay? It's a slight deviation, because we'll come back to the Commerce Clause and necessary and proper with the last three cases, Lopez, Morrison, and Raich. But the next topic focuses on the spending clause, okay? Now, we often refer to the spending clause or the spending power in the Constitution, but there's no actual clause in the Constitution that allows Congress to spend money. It says Congress shall have the power to lay and collect taxes, duties, imposts, and expos, and pay the debts and provide for the common defense and general welfare. Right? So they can tax, they can pay debts, but there's no clear power to spend money on whatever they want. So early on, there was a very important debate between James Madison and Alexander Hamilton through all these debates. Okay? Madison argued that Congress has power to spend money, but only to do that which is enumerated. So for example, they have the power to have a postal service. They can spend money on buying horses, wagons, and mailmen, and things like that, right? Hamilton argued a much more broad power, that they had the power to basically provide for the general welfare, which means whatever they want. It's unclear exactly who prevailed here, Hamilton or Madison, and the case was a little bit fuzzy. But generally today, as a matter of current law, Congress can spend money on just about anything, whatever they want. It's not limited by what's in Article 1, Section 8. But the spending power has one very important limitation. Okay? When money is being given to the states. Now, everyone know the expression, there's no such thing as a free lunch? Right? Even in law school, when there's someone giving out food, they probably want something from you, right? There's a free lunch for an event, come on by, and they're probably going to ask you to do something, right? When Congress gives money to the states, they're not just doing it to be nice. They're doing it because they want something in return, whatever it happens to be, right? Congress can't tell a state, you must do X. They're not allowed to do that. But what they can do is say, hey, you want this money? You want this nice federal money? If you do X, we'll give you this money. It's in the form of a contract. The federal government takes taxpayer dollars, which they collect, and they can give it back to a state with conditions, with strings attached to it. This is what's called conditional spending. Conditional spending, right? The idea is, we'll give you this money on the condition that you do X. Okay? And if the state doesn't do X, they don't get the money. Now, what's the problem with this, right? Why can't Congress decide how they spend their own money? That is the issue in South Dakota v. Dole. What sort of conditions can be placed? By the way, this is not Bob Dole, it's Elizabeth Dole, who was his wife. She was the Secretary of Transportation. What sort of limitations what sort of limitations can be placed on the spending of federal money? And Dole represents a case where the court put some limits on how that money can be spent. All right, Dole, I'll come back to you. What are the facts in Dole?
So the general idea was that, like you said, that the federal government wants to give money, but there's strings attached. They wanted them to increase the age of alcohol consumption, right,
Okay.
from 19 to 21, I think.
Yeah.
And what else?
Well, what did they? Why would the state increase its age from 19 to 21? What would they get out of it?
Well, I mean, the federal government wanted them to do that. The state didn't want to do that, right?
Right, but if the state increased the drinking age from 19 to 21, what would the state get in return? What's the incentive?
It was highways, right? It was,
highway.
So it was basically the federal government would spend on the highways. Would
Highway money.
improve,
Good. Yes.
yeah.
Very good. So if a state wanted to get some funding for federal highways, they had to raise the drinking age from 19 to 21. Now, Evan, could the state just come along and say straight up, "Hey, Oklahoma or South Dakota, or whatever, you guys change your drinking age now"? Could they do that?
The Congress could not tell the state to change
Why
their
not?
drinking age because that's power that lies within the state.
Yes, the state has the police power. They can make their own laws for health, safety, wellness, etc. But can they condition the payment of funds, Evan, on raising the drinking age?
Yes,
Okay, why?
because it is for the general welfare because they're trying to decrease drunk driving on the highways.
Okay, that's the answer, right? So Congress says we want to have a decrease in drunk driving, and we want to have this nationwide. We found a problem that when, imagine some of you live near in Dallas, right? Let's say the Texas drinking age is 21, and Oklahoma it's 19. What's everyone going to do? They're going to drive to Oklahoma and get drunk, right? That's probably not. They can get beer here, but in theory, right? People who live near borders will drive to adjacent states and get drunk. Teenagers. And if they do this, it will make the interstate highways not safe. Yes, I can't read the name tag. Kim, yeah.
I was just gonna say, yeah, I like the way they put it in there. They said it combines their desire to drink with their ability to drive.
Yeah, pretty good. Pretty good, yeah. So she said it combines their ability to drink with their desire to drive, right? No, their ability to drive with their desire to drink. Yeah, which I think is a good way of putting it. So Congress decided that in order to make the interstate highway safer, we're going to put conditions on funding. Now, the amount of money at issue is not very much. It's a fairly small amount. I mean, we're talking a few $1 million. I did the math. It's not a lot of money.
5%.
Yeah, but it's 5%. And there was actually a brief written by John Roberts, the current Chief Justice, who was then in private practice, where he actually did the math. And it was like a few $1 million. We're talking not a lot of money. I mean, $1 million to us is a lot, but for highway, it's potatoes. So Jonathan, what did the court do here? Could Congress put these strings, these conditions, on the expenditure of money?
Well, the majority said yes, but I agreed with the dissent and said no. But
Okay.
it was like a 5-4 split, wasn't it? It was
No. It was O'Connor was dissenting alone.
She said some really brilliant stuff in there about overreaching and underreaching that I agreed with.
All right, well, I'll tell you what. Let's start with O'Connor, and then JC, I'll come to you for Rehnquist, since you're so passionate about O'Connor, right?
Yeah. It overreached, number one, because what about the people who aren't driving between 19 and 21? Now you've infringed on their rights and states' rights to allow them to drink. Then it was underreaching because she said that, well, what is the percentage of actual teenagers who are drunk driving as a part of the whole national problem?
Okay, so Jonathan put forward two phrases which are very good. He said overreach and underreach. I think the word she uses is over-inclusive and under-inclusive, which is the same thing you just said, right? So what O'Connor's saying is this law doesn't really make sense, right? First off, how many people who are engaging in drunk driving are between the ages of 19 and 21? Small, right? I mean, it's going to be a small percentage of the population. Maybe that's because they can't get access to alcohol readily, but in general, it's a small percentage of the population. But also, what's the connection between underage drinking and highway construction funds, right? O'Connor's like, it's a pretty weak connection. The condition isn't regulating how you maintain your highways. It's regulating something else. It's regulating how you maintain your safety laws for drinking, which doesn't even limit itself to highways. So what Justice O'Connor would do is put limits on this. She would say, when Congress puts a condition, they have to put the condition on the thing being regulated, right? So if the condition is about highway spending, it has to regulate how you build highways. You can't regulate something exterior. It has to be, there's a word, germane, right? Or you might say germaneness, which is sometimes how it's spelled, right? Germaneness. What does germane mean? It has to be related to. It has to be connected. In other words, you can't dangle highway funds as a way to get them to change drinking ages. These are different matters. Now, what if, for example, they said, we will fund your substance abuse program for the state, right? We will give you money for teenage drinking, right? That's a condition. We want to give you money to help teenagers who are recovering alcoholics. If you raise your drinking age. Everyone see that? That might be a closer call because there's a close fit. The money's saying we want to help you have a teenage drinking program, just say no, right? Teenage sobriety. And if you want this money, jack up your drinking age. Now maybe a state will do it, maybe they won't, maybe they think it's not worth it, but that's a choice. Okay? But under the dissent, which again was only the dissent and still really hasn't been adopted, that I think Jonathan's very, very keen on, you have to be this connection. You can't just have this broad, sweeping thing, highway safety means we can do whatever we want. Now, I'll ask you one more question, Jonathan. Why do you think Justice Rehnquist rejected such a precise test for purposes of the spending clause? Why do you think he wouldn't adopt it? Yeah, go for it.
Because he used necessary and proper in addition to the spending clause to really give more weight to it.
That's right. He applied a very flexible test to it, right? Necessary and proper. Remember this phrase, foregoing powers? We've talked about this a few more times. Foregoing powers isn't always commerce. I told you if you had to guess, it's probably commerce. But it also links back to spending clause, right? So this is what I mean by bootstrapping. You can always add necessary and proper to anything you want and get a broader sense. This was Hamilton's argument, right? That you're not limited to strictly what's in the Constitution. You can go what's necessary and proper to get there. So the majority applies a very flexible approach to give Congress the discretion of how to spend their own money. All right, everyone see that? So the majority puts forward 4 factors, JC, right? 4 limits on Congress's spending power. What are those 4 limitations?
The general welfare.
Okay, let's take them one at a time. What does it mean, general welfare?
Must be for the general welfare of the
What's it? Just a tip, when you use a pronoun like this or it, replace that with what you're talking about because it makes your answers much stronger. In writing in general, never use like this or it because no one knows what you're talking about. So what's it here?
The allocation of the money, of funds.
Yes, sir, exactly right. So this goes back to the spending clause, right? General welfare. This is basically Hamilton's argument, right? So long as the money's being spent on the general welfare, it's okay. JC, is there anything outside the general welfare?
Not if you combine it with necessary and proper.
Oh, what a good answer. What a good answer. Everything fits here, right? When you say general welfare, it means everything, right? I mean, unless they're funding some sort of corrupt, crime ring. I can't think of an example. There's probably something, right? So the first factor is basically satisfied 100% of the time. Yeah, with.
So how is this not like a blatant overreach of congressional authority and giving them the power to do just whatever they want to do?
Well, but think about it this way, right? I understand the concern, but this is Congress's money, right? Congress acquired this through tax and other means. Why shouldn't Congress be able to spend their money how they want?
I mean, you could use money to compel a state to do whatever.
Aha. Well, we get to number 3, right? We'll get to number 3 in a minute. The third factor, we'll get there in a minute. I think it'll be Ryan probably. But we'll get to number 3 in a minute. That I think answers your concern. So Jake, just give me, what's the second factor? This one's a little bit easier to apply.
Has to be unambiguous.
Well, again, what's it?
So if
Be precise with me.
If Congress desires to condition the state's receipt of federal funds, it must do so unambiguously.
Yes, sir. If I'm going to make you a deal, I say, look, Jake, I'm going to give you $1 million, and you have just something nice for me in return. I don't tell you what that is. Or, you owe me a favor down the road, right? You owe me a favor. Do you know what I want for that money? Right. So think of it like a contract, right? If a contract's ambiguous, if the terms aren't clear, you can't enforce it. If the parties aren't on notice of what responsibilities they are required to do, they can't walk into the transaction with full knowledge. If they walk into it not knowing what the heck's going on. So the second factor is what's called unambiguous, right? That the conditions, the strings, must be known. The states must be aware, they must be cognizant of their decisions. This is an important one. You can't say, states, we'll give you this money and you'll do something nice for us later, right? This is actually coming up in the sanctuary city debate, which is raging through the courts now. Certain states and cities accepted various grants of money from the federal government on the condition of doing X. And now the government has said, we want you to do X and Y. Is this Y condition, this additional thing, ambiguously included, right? When the people took this money in the outset, did they know this other condition would be added? It's being litigated now. But this second condition can be very tricky when the executive modifies precisely what the states have to do in a way that Congress perhaps didn't. In other words, does the ambiguity come from Congress or the executive? Being litigated as we speak. All right, Brian. Now the third one's the biggie, right? This is I think goes to Witt's concern. What's the third one?
Well, it says conditions on federal grants might be illegitimate if they're unrelated to the federal interest of the program.
Okay, right. So here, this is germaneness, right? They can't spend on anything they want. There has to be a connection. There has to be some sort of fit between the money being spent and what the government wants to accomplish. Now, Jonathan says, we got on the one hand highway safety funds, like cement and road asphalt, whatever, right? And on the other hand, we have drunk driving. What is the fit? What is the connection between these two things? Jonathan's like, there's no connection, they're not related. Now, Ryan, what does Rehnquist say?
Well, he says it's a direct relation to safe interstate travel.
He disagrees with Jonathan, right? He says that there's a close fit right there, right? Who's right, Jonathan, you, or Rehnquist? Who's right there?
That's Rehnquist.
Oh, because he was the majority, right? No, but not necessarily, right? The question is, how close of a fit do you need? O'Connor would require a very direct fit. Rehnquist is like, well, it's rational. It makes sense, right? When we're looking at Congress's powers, we use necessary and proper as our guide. We're flexible. So the big difference between the Rehnquist and the O'Connor is really on number 3, right? How close of a fit between the two things you need. Does that make sense? Okay. Oh yes, sir. Is it Tim?
Yeah. So on that third argument, that third principle.
Yeah.
What if the state had a law that said that only out-of-state residents, they had to be 21 years old to drink, and then that wouldn't really be the federal interest wouldn't really be.
Oh, I see what you're saying. So they said you have a different drinking age for in-state and out-of-state.
Yeah.
That might be unconstitutional for other reasons. You can't discriminate against out-of-staters. But I see your point, right?
You're not discriminating against citizens.
But it would still be allowing young, immature people to drive drunk on your own roads for your own people.
But that'd be a police power thing, wouldn't it?
That's exactly the point, though. He said, isn't that a regulation of police power? The entire point of the spending power is to give the federal government effectively a police power, right? They can't make the state change their laws directly, but if they dangle money, give them carrots, they can do it indirectly. So I think that would probably still be okay within Rehnquist's opinion. Okay? Now, Cameron, the last one, what's this last, the fourth one, this fourth principle?
The last one is if there's already some constitutional provision or some law in place that would bar you from withholding funds for that specific reason. You can't withhold it.
So what might this independent constitutional bar constitute? What might that be? Like, what does that mean, an independent constitutional bar?
Like if there's some other article of power in the Constitution, or some state which is you can't.
Okay. Yeah, okay. I'll give you an easy example, right? Let's say the Congress says, we'll give you $1 million for your highway funds if you prohibit newspapers, right? You gotta shut down all the newspapers. What would be the problem there?
Well, you can't, because Congress is not allowed to infringe on freedom of the press.
But Congress isn't doing it. They're not shutting down the newspapers.
Well, that would be, as for that fourth provision.
There you go. There, that's it, right? The independent bar is you're forcing the states to do something that itself would run afoul of the Constitution. Everyone understand that, right? So in this case, it was an argument about the 21st Amendment. What the hell's the 21st Amendment, right? That's repeal prohibition, right? 18th Amendment created prohibition, 21st Amendment repealed it. There's actually a bar in Washington, D.C. called the 21st Amendment. That's the name of a bar. Every year on Prohibition Day, they celebrate the repeal prohibition. Not that people in D.C. need an excuse to drink. I was in D.C. Recently, and I ordered a club soda for lunch at a hotel. Would you like Jack in that? I think people in D.C. are drinking way too much now. I'm not joking. It was like 11:30 in the afternoon. But the court identifies another principle of coercion. And the court says, let me read this one carefully, if the financial inducement offered by Congress is coercive, that pressure turns into compulsion, it might be unconstitutional. So Ashley, what's Rehnquist getting at there? If the financial inducement becomes coercive, pressure turns to compulsion. What's going on there?
Well, I guess I would translate that as you can't really buy your way into getting, your, I guess, what you want from the states.
So here the states were at risk of losing 5% of their highway funds, and again, I think I checked the math, it's like a few million bucks, right? If a state turns down that 5%, does the state have a viable option to, just maybe pay for the highways themselves and do something else, tax their own people? So is there really a cost to turning down this amount of money?
No.
Okay, but now what if, instead of taking away 5% of highway fund, we will take away your entire budget for, let's say, Medicaid, which is a federal health insurance policy.
Absolutely.
Okay, so where's the line, Ashley?
I think that's where Rehnquist says where I guess when it really affects how the state functions or the services that they provide to their people.
Okay, very good. The court says here these are, quote, relatively mild encouragements to the states. Mild, right? He's probably right. I think here the amount is pretty trivial. But you'll read the next case for class on Tuesday, the Obamacare decision, where the states would lose, as I alluded to a minute ago, 100% of their Medicaid funding. In some states, it's 20% of their budgets. That, the court says, runs afoul of Dole, right? So the NFIB case actually breaks the fourth principle, the fourth rule in South Dakota v. Dole, right? So Dole was, 1986, 85, whatever year it was, basically 30-something years until they actually found a case that broke it, and it was the Obamacare decision. Okay? So we did Rehnquist, we did Justice O'Connor. You have to know the four principles, right? Know those four principles. They're not hard to remember. And always pay attention to, the first one's whatever, it's easy to satisfy. The second one, is this ambiguous, right? Is there some sort of ambiguity in what's actually required of the states? And then you have the third one, is it related, right? Is the money being spent related to what they want the states to do? And using necessary and proper, it's pretty flexible. You don't need a tight connection. That's what O'Connor was like. And the last one, the fourth factor concerns, are there other constitutional bars? And the Supreme Court found in the Obamacare decision that if there's too much money, it becomes coercive, and that actually infringes on the states' rights in the 10th Amendment. That's a no-no. Okay, and I think we already did O'Connor's dissent before, but again, she dissented alone. No one else joined her on that one. Is that Henrietto? Yeah, I got to use a darker marker so I can see that one.
Yeah, apologize.
It's
Is
okay.
that Breyer dissent tool in that case?
Breyer?
Or Brennan?
Oh, Brennan. Yes. Brennan. Yes, Justice Brennan dissented as well. Yeah, he had a somewhat idiosyncratic view on the 21st Amendment. He basically thought the 21st Amendment, this repeal of prohibition, was an independent constitutional bar under that final factor. I'm not too concerned about Brennan, but he did.
But you don't think that's important for us?
Not really. I would probably take out the book, but it's there. Okay. All right. Any other questions on Dole? All right. The next case I've alluded to a few times already. It's called United States versus Lopez. Anyone from San Antonio? Okay, so this case actually arose in San Antonio at Edison High School, which I have a picture for here. I actually got, I can't remember who sent them to me. Someone sent me a copy of the Edison High School yearbook. So this is Alfonso Lopez in his yearbook. And here's you can see his name, Alfonso Lopez, right there. And here's a picture of him playing soccer for the team. I wish I had a not so blurry picture, but that's the best I got. Who's up next? Sophia, you want to give us the facts, please, here?
There was an act that was passed in the 1990s called the Gun-Free School Zones Act that made it a federal offense for anyone possessing a firearm within 1,000 feet of the school.
Okay.
And a 12th grade student arrived at that high school with a concealed handgun and was arrested and charged under Texas law.
Okay, whoa. He was charged under the federal law or the state law? At least initially.
Initially under the Texas law.
Good. Okay. So, initially, Sophia's right, he was charged under a Texas law which prohibited carrying a handgun in a school zone without a license. Okay? Now, Sophia, why didn't the case end there? Why didn't Texas just prosecute him and just be done with it?
Because Lopez argued that the original act, the Gun-Free School Zones Act,
the initial question is, why wasn't he just tried in the Texas state court system for violating state law? That's the initial question.
Because the Texas law conflicted with the...
No, Laura? Does anyone know? Yeah, John?
Why foot the bill if the government will do it?
Oh, so think of it this way, right? You're taxpayers, right? You pay for the Harris County DA money. If Mr. Lopez was going to be tried in the state court system, it's going to cost you. You have to pay for the prosecutor. You have to pay for the jail cell. He's being incarcerated. You have to pay for his food, for his containment, everything else. If he goes on parole, you have to have probation officers to follow the guy around. There's a lot of cost involved in actually prosecuting someone. But there's a freebie to be had. If the feds step in, we don't have to do it, right? Texas doesn't have to foot the bill. So because this federal law had been enacted fairly recently, the U.S. Attorney in San Antonio came in and said, hey, Texas, give Mr. Lopez to us. We'll take care of him. Take care of him, right? But we'll prosecute the guy. Also, the feds were looking for a case to test out this new statute, see how it works out. So basically, Texas said, all right, you guys take him. By the way, if you follow this incident in Michigan, right, this guy Nasser, right, he already had a life sentence in federal prison for child pornography. He was sent to state prison subsequently for the abuse allegations under state law. So you can have simultaneous prosecutions. The double jeopardy clause doesn't apply to the dual sovereigns. You can be tried for the same crime twice by the states and the feds in either order. So even if Lopez was acquitted on the federal charges, he could then be brought up on charges under state law. So the feds are like, okay, we'll take him first, you guys get him later. Yeah. Is that Cameron?
Well, I was just supposed to ask if being, states unconstitutional. They said in Texas just common sense.
I don't know if Texas went after the guy. I don't know the answer to that question. I doubt it. At this point, he probably in his 20s, and it's like, whatever. Yeah, Jonathan?
So did the trial court and the appeal court both find him guilty, and then it got to the Supreme Court? Because it doesn't say, it just says affirm the appeals.
So, if I remember correctly, I know the Fifth Circuit ruled in favor of Lopez. So here's how you know it, right? The case is called United States versus Lopez. United States comes first, Lopez comes second. Which party is appealing in the case?
I thought they couldn't. I thought that goes against res judicata if they do that.
I don't know. So here's what happened, right? Let me walk you through this. Lopez was indicted in federal court, right? His attorney, what's the guy's name? I found his name somewhere. I always like to mention it. Jack Carter, federal defender in San Antonio. He decided to move to dismiss the indictment on the grounds that the statute could not reach his client's conduct. Now, I always stop and mention this point because it's important. Any of you have internships with federal public defenders coming up this summer? Okay. Federal defenders are very much overworked. They have a high caseload. They're not paid very much. They're not treated particularly well usually, and they defend some pretty bad people usually. But they have such an important job in our system. Generally, federal defenders have one option: it's to accept a plea bargain, right? Let your client plead guilty. He goes to jail. You don't have to do the expense of trial. What's the risk of going to trial? The sentence might be greater. What the government usually do is they'll let you plead to a lesser charge and a reduced sentence if you skip a trial and just take a plea bargain. Okay? So you got Mr. Lopez here, right? Guy had the gun. There was no doubt. He brought the gun to school. There was no doubt. He was guilty. He was guilty under the statute. So a lesser public defender would have said, you know what, let's just plead guilty, let this guy go. You know, might spend a few months in jail, might spend a year in jail, then he'll be out. But his lawyer had the foresight to say, wait a minute, this statute might not be constitutional. Now, it's really easy for you guys to sit here in 2017 and say, oh, of course, commerce, channel, instrumentality, substantial, you know, you can say that, reading the opinion, but at the time, if you had gone to law school in the 80s, your professor would have told you the Commerce Clause means whatever Congress wants it to mean, there's no limit. Wickard v. Filburn, Wickard v. Filburn, parts of Atlanta, Katzenbach, do whatever they want. But this guy, Jack Carter, this defender in San Antonio, had the foresight to challenge the conviction, saying, you know what, we're going to challenge this indictment before even a trial happened, so he was never found guilty. Prior to the trial, you challenge the indictment, right? And if I remember correctly, I think the trial court dismissed it. And then the government appeals. And I'm pretty sure the Fifth Circuit Court of Appeals, based here in Louisiana, agreed and said, no, this can't be conviction. That's why the case is called U.S. v. Lopez. This is a little trick for you. The party that comes first, like whoever's name comes first, that's the party that lost below. They're appealing. The party appealing is the first name. So U.S. v. Lopez, United States lost. So this case comes to the Supreme Court with the first meaningful challenge to the Commerce Clause, like in 4 or 5 decades. It's a very long time. Okay? Yeah, Damon.
So why the feds were willing to incur the expenses and like take it?
They wanted to try out this new statute. This was a new statute. They wanted to try it out. It's probably a bad choice, but they wanted to see how it works. Also, this was during the Clinton administration. They're tough on guns, you know, gun control. This was part of their mission. Yes, sir.
You know why he was bringing a gun to school? Was he?
I'm sure there's not a good reason for it. There's not a good reason for a gun to school. I don't know. He was 18 at the time, so he was actually the age of majority. Otherwise, he would have been a minor. But I think he was 18 at the time. Yes, sir.
I just want to add, it says here that he was going to get $44 for it.
Were you reading this?
Wikipedia.
That's my thought. I don't trust Wikipedia as a general matter. I encourage you not to read it. I don't know. If you find that in a reputable source, I will vouch for it, but I can't vouch for Wikipedia. But thank you for that. Yeah, there's usually not a good reason to bring guns to school. But here it is. Now, his lawyer challenged the indictment. It comes to the Supreme Court. Now, the easy part is the Supreme Court says that this conviction can't stand, right? That this statute can't be applied to him. As the case was being appealed up, Congress enacted the statute again with additional findings and saying this affects interstate commerce. Right? They basically tried passing the statute again, but it can't apply to Lopez. Why? Why can't a statute passed after the offense be applied back to Lopez?
It cannot be retroactive.
Yeah, what do we call that? What's that clause in the Constitution? A couple you said it, yeah. Yeah, right there, Mina? Ooh, you said so close. Flip it.
Ex post?
Yeah, there. Ex post facto. I think you said post ex facto. Very good. So under ex post facto, he can't be prosecuted in this new statute. So basically, the effect of this case was absolutely nothing, right? They struck down this statute, and it was never applied ever again because they relied on this new statute, which had the correct Commerce Clause connection. So the major problem with the statute was primarily a lazy Congress. What about that? They didn't say certain things they could have said to solidify why this was permissible. All right, so let's walk through the opinion, okay? This case is also a very good case for your notes because it provides a very straightforward summary of the case law doctrine. The case law doctrine to the present. And Chief Justice Rehnquist identifies 3 categories of economic activity that Congress can regulate. There are these 3 categories, and Clinton already stole my thunder, but the acronym is CIA. I know, I love that you watch me carefully, keep me honest, it's good. Do I have something crazy, Clinton? Every time I read these cases, I see new things.
Yeah.
Do you believe, I mean, I've now read this case probably a dozen times. Every time I read it, I see new things I didn't notice. It's the most amazing thing. I mean, you think professors just, look at their lecture notes. I read the cases every single year, and I see new things. Maybe I'm right, maybe I'm wrong, I don't know. But I always look at the cases differently, maybe what's going on in the world. I always see different things. Usually, whatever the current event is, usually tweaks my thinking. So this year, I was thinking about sanctuary cities, and I reread Dole in a completely different way.
I like that you changed your opinion from semester to semester, and it made sense both ways.
Yeah, and with a 5-4 case, I often go back and forth. Sometimes I disagree with myself often. The Supreme Court, I think it was actually Justice Jackson once said, the Supreme Court is final because we're last, right? But it's not because we're right. Their decisions are final not because they're right, but they're basically the end of the road. Fortunately, I'm not. I'm just a low-level pawn. So, God, where am I up to? Laura, you next or Sharon? Okay. So, Chief Justice Rehnquist has this acronym or mnemonic device. The channels. Here, I'll write it out for you. Channels, instrumentalities, and activity. Right? Okay. Okay. Channels, instrumentalities, activity. This is the way I remember it, at least. So, what are these channels of commerce, Laura, that he's talking about? Channels of interstate commerce. By the way, CIA is how I remember it. That's how I learned it. I don't know if it works for you or not.
So the channels of interstate commerce. I guess is he talking about like the trading?
What's a channel? What does that word mean? Not like on a TV.
The different, like the medium they're using.
Yes. Roads, right? Highways. Okay? Channels of commerce are the various means by which people engage in interstate commerce. So, for example, Heart of Atlanta Motel, right? Heart of Atlanta Motel. How did the customers get to Heart of Atlanta Motel?
Highway.
Interstate highways, right? So even though the act of staying in a hotel, right, you're sleeping in a bed, that itself is not interstate commerce, but the act of getting to the hotel, that is an economic activity on a channel of interstate commerce. Again, maybe there were local people staying there, maybe people from Georgia living in that hotel, but some of the customers were traveling on interstate highways. Okay? What's an instrumentality, Shara?
The way I kind of took it's more just like the pawns of how it is.
The what?
Kind of the pawns of
Pawns?
interstate commerce.
Oh, that's my word a minute ago. What do you mean a pawn? Yeah, I like that word.
way he said Congress is empowered to regulate and protect the instrumentalities of interstate commerce or persons or things.
Things. Okay, what are these things? What's a thing of interstate commerce? I like that explanation.
Kind of like with your little matchbox thing. It's
yeah.
something that was made in a different state.
Yeah, it's a thing, right? Yeah, exactly. Or I'll give you a better example, a train, right? Imagine this. Imagine you have a train that could cross over state lines, but the route is just within one state. But the fact is, it's a train that could be used as an instrumentality of interstate commerce. Congress can regulate train rates, even if the train is not crossing interstate commerce, because a train is an instrumentality of commerce. It's a thing that can be used. Semi-tractor trailers, right? They may cross state lines, they may not. But it's an instrumentality of interstate commerce. Yeah. The channels one is easy to understand. Instrumentality is a little bit fuzzier, right? As you go down this list, CIA, the connection to commerce becomes weaker and weaker and weaker. You notice that. The third one, though, is the trickiest one. Okay, so then, there you go, Donnie. Donnie, what's the third category of economic activity that Rehnquist talks about here?
Activities that have a substantial effect on interstate commerce.
Very good, very good. So economic activities, and if you notice, I keep saying economic activities. Keep that word economic in mind, because we'll find out later possessing a gun is not an economic activity. So, which is how Rehnquist writes his opinion. But Donnie's right. An economic activity with a substantial relation or substantial effect on interstate commerce. And this is Jones and Laughlin steel, right? The wages of local steel workers has a substantial effect in interstate commerce, even though the wages themselves are local in nature. Okay? So we're going to get to three categories. This is still good law. The CIA, that's still good law. But the tricky part is the third one. Yeah, go ahead.
So this is just a question, kind of a curiosity. Why didn't you talk about Ogden when you were talking about instrumentalities? Why didn't you talk
Gibbons v.
about,
Ogden?
Yeah, the ship. That is an instrumentality case, right?
It involved, well, Gibbons v. Ogden is an easy case because it literally involved a ship going from state A to state B.
Yeah.
Right? The cases here, right, parts of Atlanta, etc., wasn't exclusive at going from state A to state B.
Okay. So that's not really.
So, right, I would say that the Gibbons v. Ogden, this is the steamship case, right? We did the first week of class. If you had to ask me, Clinton, I would say Gibbons v. Ogden is straight up interstate commerce. It literally is by itself. It's not a channel of interstate commerce. It is itself interstate commerce. Okay. Right, delivering of goods and people across both one state, New Jersey, New York, that is by itself interstate commerce. Okay. Make sense? Yeah, JC.
So the train shipping lottery tickets in Champion v. Ames, would that be an instrumentality then?
Yes, if the regulation was on the train shipping it, that would be right.
Okay.
Yeah, Jonathan?
Wickard would be activities, isn't it?
Well, Wickard falls into the third one, right?
Yeah.
You're right. That's right. Which as I think I reflected on bringing the case yesterday, needs necessary and proper. We'll get there. Right. The reason why I don't like the Rehnquist opinion is he doesn't really talk about necessary and proper, and the dissent nails him on this in a very big way, I think. So let's talk about this. So the Gun-Free School Zone Act, right? It's not a channel. Right? Simple possession of a firearm is not a channel. Okay? Now, is that Mina?
Yes.
Was a gun at issue made in Texas? You know? The gun that Lopez brought to school, was it made in Texas? Yeah, I'm not sure either. Do you think some of the parts that came from this gun were from outside of Texas? I think that's a good assumption. Yeah, I think it is. So why is this not a thing, like a lottery ticket, right? Why is this not instrumentality, a thing in commerce, like a matchbook, for example?
Well, Justice Rehnquist, was contrasting the thing to Wickard, the wheat and Wickard, and basically he's reasoning that there's the thing, the gun, it doesn't affect the greater whole, overall.
No, you're right, but look, wheat comes from the ground, right? It's a seed. It's completely interstate. The wheat grows in Ohio. But if I had to guess, this gun came from out of state. Maybe I'm right, maybe I'm wrong. Let's just say I'm wrong, right? If the gun came from out of state, why is it not like a lottery ticket?
Because
the gun is on the individual within the state. It's almost like a local.
But the gun itself, the same way that in Hearts of Atlanta, right, passengers came from out of state. Or in the Ollie's case, barbecue, their meat came from out of state. Why is this not like that? If the thing regulated, the gun, had out-of-state metal, out-of-state wood, whatever it is, why can't Congress regulate that?
Well, the reasoning that I'm getting from the opinion is that there's no substantial relations interstate.
You're right. You're on the third one. You're on A. No, I'm not on A. I'm still on I. Right.
Oh.
The third one. Why is a gun not an instrumentality? Why is a gun not like a lottery ticket?
Well, it's so.
I
The
mean,
lottery ticket was a danger. It traveled.
Yes, it was a gun. Didn't the gun almost certainly come from out of state? Let's say pretend it did. Let's say Lopez got the gun from Oklahoma. Let's make it easy on you. Why is it not an instrumentality?
Well, the way you're asking this to me, I want to say, well, then it would be an instrumentality.
Yes, exactly what I'm asking. You're following my bait. Okay, so then Lauren, let me ask you. Why didn't that satisfy the court then? The fact that this almost certainly came from out of state. I mean, it was a 38 special. I mean, it was probably Smith and Wesson. I mean, I have to guess. I'm sure Wikipedia will tell you the answer. But why is this not enough to know that the gun could have come from out of state?
Is it because they never made that connection?
Who's they?
Congress.
Exactly. Congress never said the gun has to travel in interstate commerce. Remember I said a few minutes ago they reenacted the statute like a couple years later? When they reenacted the statute, they basically said, and the gun has to have a substantial effect in interstate commerce, it's a travel in commerce, whatever. Congress was lazy. They forgot. They passed a statute and they become so accustomed to the Supreme Court rubber stamping everything, they didn't put in one damn sentence linking the gun possessed to interstate commerce. The failure to make that connection in the statute, Rehnquist says there are no findings, right? This is what's called the hook, or the connection, right? What is the hook, or the connection to interstate commerce? They just didn't do it. Maybe it's that laziness, who knows, right? But Lauren, 100% correct. They didn't make that finding. And it was partially on this basis that they struck it down, right? Now, Matt, the dissent, was it Breyer? Does he think you need to have this sort of clear connection in the statute to uphold it?
No.
He doesn't. Why not? Why does Breyer not think you need to have this? What clause is Breyer going with?
I don't recall a clause.
Oh, you know it. Come on.
The commerce.
No, the other one. And what does necessary and proper get you?
It gets you whatever you want.
Yeah. So this is why the Rehnquist opinion always troubles me a little bit, right? It always does. Maybe that's why I changed my mind from last class. Who knows? I was reading this in the plane the other day. I'm like, oh, I'm thinking about it. Under the necessary and proper clause, Congress has latitude. And traditionally, Congress didn't need to make specific findings about how the thing, the instrumentality, right, has a connection to interstate commerce. Right? Think of the barbecue case, Ollie's barbecue, Katzenbach. Did the statute, necessarily say, well, if they import this much food from out of state, that's enough? Maybe, maybe not, right? But what the court said is, as long as Congress has a rational basis, what do you mean by rational basis? They have some reason why they could expect a gun to travel in interstate commerce, the court should defer. What Rehnquist did in the Lopez case is he dialed up the scrutiny. What do you mean by that? He's going to say, we're going to put this new burden on Congress. We're going to put this responsibility on them that if they want to regulate an instrumentality, they have to explain why it should be regulated. They have to explain what the connection is between this thing, this gun, and interstate commerce. Second, Gabriel. The failure of Congress to do this means you don't get the instrumentality, right? Even though this is not much of a lottery ticket. I keep going back to the Champion v. Ames case, the lottery case. it's not, I think Nina was trying to fight on this, but it's there, right? It's the same idea. Shipping lottery tickets, right? Possession of a gun. The fact that Congress reenacted the statute with like a few extra sentences saved it. But here the court was willing to give them the benefit of the doubt. Gabriel, patiently waiting.
Yeah. I was just gonna say, adding to an incident proper, William Breyer said that.
Breyer.
Breyer.
Good, yeah.
He said, Congress could have found the gun-related violence near the school, could have affected education.
Yeah.
And then therefore it would be low-paying jobs and the community business.
You find this persuasive? Yeah. So Breyer's saying, look, it's not that hard to think of what the connection is between a gun and interstate commerce. If there's guns in school, kids aren't learning well. People aren't learning well, then, you know, they get bad grades. They get bad grades, they don't get good jobs. No jobs, no economy. Boom, right? You gotta, you know, inference, right? Martin, what does the majority respond to these sorts of, this chain of reasoning that Gabriel mentioned a minute ago? Does the majority think that chain of reasoning is persuasive?
They don't.
No, they don't at all. Why not? What's Rehnquist's problem there?
Crazy because you could just pretty much infer to anything.
Okay. Yeah, exactly. Right? In other words, what's the limit? Right?
Yes.
What is the limit? If you take the, and Gabriel I think stated it very well, right? If there are guns in school, kids don't learn well. Kids don't learn well, they get bad jobs, bad economy. If you do that, is there anything Congress can't regulate? So the basis of the majority opinion here, the basis of the majority's opinion is there has to be some limit. You can't give the federal government a police power, a general power to regulate local stuff. And what they say is you can't pile inference upon inference upon inference. That is not permissible. Yeah.
Yeah, but it's not like it's 6 degrees of separation. It's pretty direct what Breyer says. It's only 1, maybe 2 inferences away. It's not that many.
So how many inferences is too many inferences?
Well, with Wicker, they were fine drawing all those inferences, and now all of a sudden they're taking a totally different direction about it.
That's correct. Well, that's correct instrumentalities, right? But where the opinion distinguishes from Rickard is on the third one, activities, right? Who's that? Yeah, David. Is the growing of wheat an economic activity? Well, growing wheat? What did the court say? Yeah. Is that an economic activity? Forget interstate, intrastate by itself. Is growing wheat an economic activity? No, just the act of growing wheat. Is that economic in nature? Well, you don't think so. What did the court say? Yeah, okay. I actually agree with you. So the court said that the growing of the wheat in Wickard was an economic activity, agriculture. Now, Dave, I'll ask you a follow-up. Is possessing a gun economic activity?
No.
No, why not?
Oh, you asking me? Oh, I'm sorry.
Oh, Gabriel, you can take it. Yeah, you're next. Yeah, go for it.
No.
Why not?
Because it doesn't affect economic.
Okay. So, and this, Jonathan, is the answer to your question. The reason why Wickard worked under the economic activity, the third aspect, is it's an economic activity. In other words, you only aggregate substantial effects for economic activity. For non-economic activity, you're stuck with basically these two. You see what I'm saying, right? You don't get substantial effects. And Rehnquist is fuzzy on this. I'm not gonna deny. His opinion here is a little bit indecisive, and it drives me crazy every time I read it. But because it's not economic activity, because holding a gun just by itself is not economic activity, you don't get to the aggregation principle. Right? So you have to ask yourself, is the activity at issue of an economic nature? How do we know if it's economic? They give some dictionary definitions, not very helpful. But what you do know is possession, simple possession, is not itself an economic activity. Congress would need to say the connection between possession and the interstate marketplace. For example, possessing a gun that traveled to interstate commerce. Then it's instrumentality, right? But Congress failed to do that. Damon?
Yeah, and while we are on the instrumentality, I'm still not sure if I got the instrumentality right or not. So is it a means of transportation or
It's fuzzy. It's fuzzy. It's a thing used in interstate commerce. Channels, channels like a road or a highway or a river or something, right? The instrumentality is actually the thing that travels in commerce. Whether it's a lottery ticket or food or something else.
not the means of transportation? Like
It could also be a train, the thing that's actually traveling. It's fuzzy. As clear as these three categories are, they're actually very fuzzy and they bleed into each other. But the important point from Lopez is that merely possessing a gun by itself is not economic activity. Therefore, we don't get to substantial aggregation. We don't get to substantial effects test. Okay? Now, necessary and proper does come into the opinion very briefly. Very briefly. It's like a paragraph, which is why, I don't know, when I was reading it the other day, I harped on it. I read it over and over again. The court says that the Gun-Free School Zone Act has nothing to do with commerce. We're in the economic enterprise. Okay? And then the court says that the Gun-Free School Zone Act is, quote, not an essential part of a larger regulation of economic activity, in which the regulatory scheme can be undercut unless the interstate activity were regulated. Let me read that to you one more time. There's a very important sentence which I was harping on the other day when I was reading this. The Gun-Free School Zone Act is not an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the interstate activity were regulated. Roberto, you're nodding. Okay, what does that mean?
It means Congress has the power to establish schemes, like you said earlier, to keep prices down and supply up, for example.
Yeah.
But there are activities that are going to interfere with this scheme, and carrying a gun, if everybody carried a gun, it wouldn't affect an economic activity or much.
You don't have to agree with that. I just want you to explain it to me, right? I think you got it right. Okay, very good. Again, I don't care if you agree with his opinion. It's actually largely irrelevant. I often go back and forth on all these things, as I think I illustrated earlier. I change my mind on stuff quite frequently. Every time I read, I see different things. What the court's saying here is that in Wickard, right, the reason why the substantial effects test worked was because Congress had the power to create this broad scheme by keeping the prices high and keeping supply low. If someone grew local wheat, it would undercut that marketplace, right? Because if Wickard's growing his own wheat, he doesn't need to go to the market to buy more. Okay? So because the locally grown wheat was part of this larger economic regulatory scheme, they can reach this local conduct. Through which clause, Roberto?
Commerce?
No.
Necessary and proper?
That's right.
Right.
Yeah, you got it. Good. So it's necessary and proper that lets you regulate substantial effects. This, I think, is the reason why I changed my answer. I don't know. I'm pretty sure. Makes sense, Clint?
Yeah, I go back and forth now.
You see, right?
Yeah, I understand.
But Rehnquist doesn't make this connection clearly, which is why I think I maybe said the wrong thing last. I don't know.
I don't know if you said the wrong thing or not.
I don't know. But the point here is he's saying, at least here, when you have this complicated scheme, you need necessary and proper to go after local economic activity, which then you can aggregate substantially. This is Scalia's opinion, Raich, though. That I can say without any question. In Raich, we'll do this a little bit later, Scalia says, Congress has this power to regulate drugs nationwide. If you can grow weed in your backyard, you're not going to the local dealer, right? And if you're not going to the local dealer, you're going to screw up Congress's entire approach to controlled substances, right? They can't, arrest every backyard weed grower. They can't do that. So what Scalia says is you can reach locally grown marijuana, even though it's intrastate, because it undercuts this nationwide war on drugs. And that is how Scalia understands Wickard. That's what Rehnquist is getting at. He doesn't. I don't think he cites Wickard here. I don't think he does, but he should. But that's what they're getting at. Yeah, this Rehnquist being drives me nuts every time I read it. Yeah, Cameron.
Do you think maybe because Rickard was kind of that last case and he gave it such expansive powers, was this case was bringing it in? Maybe that was the reason he consciously.
He may have been I don't think. Yeah, that's possible. He didn't want to cite it. I think that's entirely reasonable. I think you're on the right track. Okay. Okay. Is there a hand up, Jonathan?
No. The fact that it's a 5-4 split again, does that mean this is going to come back and switch?
Well, I mean, look at Raich, right? Raich a couple years later went the other way. I also think Rehnquist was still figuring it out. I don't think he had the answer clear yet. But that paragraph about the larger economic scheme, that's the biggie. Okay.
Where is that paragraph? Has anyone got that?
Is it not in your book?
It's on 271. First.
Thank you. What page? I don't have the page in front of me.
271.
Okay.
You got
Sorry.
it there?
Yeah,
I read it. I read it.
Wow.
I read it yesterday, so I know it's there.
Okay, sorry.
That's okay. That's okay. But yeah, he doesn't make a big deal about it. But that I think is right there the reason why I changed my answer from last year. So questions on that part, okay? So the long and short of it, right? It's a fairly complicated opinion. But why is this Gun-Free School Zone Act unconstitutional? First off, there's no economic activity at hand. Merely possessing guns is not an economic activity. Second, Congress didn't make any findings, a connection, or a hook, you might say, of how this connects to interstate commerce. Okay? And third, this is not a channel or instrumentality by itself. So you can't get under channel, you can't get under instrumentality, and it's not an economic activity, so you can't go to substantial effects. So it doesn't fall anywhere within Congress's commerce or necessary and proper powers. Nani?
Repeat the last part again about the, I think you said the gun wasn't something that
Oh crap, what is that? The gun.
So you said activity first. And
Yeah,
then,
yeah. So
second
just
was
go
the
through them,
hook.
right? It's not a channel. It's not an instrumentality. And it's not an economic activity. It's an activity for sure, having a gun, but it's not economic in nature. And because it's not economic in nature, you don't get the substantial effects test. You don't start aggregating together. I think that's the easiest way. This opinion, he does a good job summarizing the case law. The analysis is muddled. You have to keep in mind, the court hadn't done this in 6 decades. They maybe didn't quite know what they were doing, and it's scary when you think about it. But they often are winging it when they get to these new sorts of cases. By the way, if you guys think this stuff is a little bit fuzzy and unclear, wait till we do the 14th Amendment and gay marriage and abortion. You're going to actually yearn for tests like these. You're actually going to miss these sorts of things. Those cases are much more fuzzy. Clinton, is your hand up a minute ago?
No, I'm just reading.
Okay,
I'm
good.
Thank you.
All right. Yes, sir, Andrew.
So can you explain more about the Dole sovereignty clause? And, how does the supremacy clause come into effect?
Are you going back to the fact that you prosecuted by the states and the feds? Is that your question?
Yeah.
So you're thinking of the double jeopardy clause, right?
Yeah. Well, I understand the
Right.
double jeopardy
So,
clause, but
so the double jeopardy clause says you can't be tried twice for the same offense, but that's by a single sovereign. And the courts have held you can be tried by separate sovereigns. In other words, a federal prosecution doesn't stop the states from prosecuting you again. And if you think about it, it this way, right? Someone commits, some sort of crime, right? Someone robs a bank in our town, right? And the feds come in and prosecute him, and he's convicted. But the people of Houston are very angry that he did this. Why can't Houston prosecute him again for robbing that bank? I mean, wouldn't that be promoting federalism to let 2 prosecutions occur? Or think of this case from Michigan, too, this guy Nasser, right? He did all these awful things. The feds got him on kidney point charges, and they got him again under state law charges for molestation, right? So he's basically being charged twice with the same group of conduct.
I was wondering if the supremacy clause, does that affect that at all, for example?
No, they're different crimes, right? The exact same offense can be a federal and state crime, right? Bringing a gun to school violated Texas law and violated federal law. They're not in conflict at all. The states and feds criminalize the same act.
What do you think, like, the legalization of weed, for example?
Oh, good question.
Federal standpoint, and they go after somebody,
state of Colorado.
That's fine. Marijuana remains a controlled substance in federal law. We actually may see prosecutions in some of these states for federal marijuana violations. Even if Colorado or Washington legalized pot, that doesn't do anything to federal law. It doesn't change it. And the feds can come in and shut down your hothouse.
Did they say under Raich that they want you to be able to experiment with different things?
That was a dissent, my friend. That was O'Connor's dissent. Again, you're O'Connor's BFF today, right? That was a dissent. That was not the majority. Yes. And by the way, even the O'Connor dissent was about personal consumption, not the sale. If you go to Colorado, you have legit stores in the streets selling weed, right? That's not for personal usage. That's like commercial, literally commercial activity, which you could substantiate. I mean, again, selling weed, right? Let's just go here. That's an economic activity, and you can use substantial effects to regulate it. So if you have a weed shop in Denver, and there are a lot of them, the city, has anyone been to Denver? You can smell, it's awful. I think it's awful, but I'm a square. You have no idea. But the fact that it's an economic activity means you can aggregate them under the substantial effects test. So absolutely Congress under Lopez could shut down those local dispensaries. So during the previous administration, the Obama administration said we're not going to go after the sale of marijuana at low levels. They basically were just not going to prosecute those cases. That policy has now been revoked. It's up to the local U.S. attorneys to prosecute it. We haven't seen it yet. We might. But all those businesses are mostly cash because they're acting outside the law. No bank in their right mind would open up a line of credit for a business selling illegal drugs. So these are all cash businesses, and in fact, it's very difficult. It's very difficult what they're doing. All right, anything else on Lopez? All right, let's go into. Oh, I think I did the dissents, but basically, Breyer would allow you to put inference upon inference, and well, like Gabriel said, you have guns in schools, kids don't learn well, it hurts the economy. The majority rejects that. But I think Breyer's test is consistent with the Warren Court, right? The same way Breyer aggregate, I think that's Wickard, I think it's Hearts of Atlanta, I think that's Katzenbach. I think Breyer was actually consistent with those other cases. And the majority, I think, pushed, or at least drew a line of what they were willing to do. Okay. I'll note briefly that Justice Thomas, in the concurring opinion, he is what he would call an originalist, that he tries to read the Constitution as it would have been understood at the time it was drafted. And he looks at the word commerce, which means the sale of things, right, not possession of guns. What makes Justice Thomas very unique is he doesn't have a very strong conception of stare decisis, precedent. He doesn't. And he's always willing to second-guess long-standing precedent if he thinks it's inconsistent with the Constitution. That is, he holds the Constitution itself, as he reads it, over any Supreme Court decision. So Thomas's decision would bring you not just back to Wickard, but probably would go back to Gibbons v. Ogden about what interstate commerce is. He maybe go further than that. But Justice Thomas is unique on the court in that respect. Any other questions on Lopez? Okay. On to the next case. Next case is United States versus Morrison. And let me explain briefly. Lopez, what, 95, 96? In the 4 or 5 years after Lopez, there was a lot of uncertainty about what this case actually meant. Would the court start striking down laws? Would they go back to the New Deal? No one quite knew what the court was going to do. The next case that implicated the Commerce Clause was Morrison. It involves VAWA, the Violence Against Women Act, which, despite its name, isn't really about violence against women. It's about violence in general. It's men and women alike, but that's a more popular name. It was actually Joe Biden's proudest moment in the Senate. This was his crowning achievement. The case itself involved Christy Berzoncalo. She was a student at Virginia Tech, which is a state institution. She was sexually assaulted by a couple football players. Nothing new, right? The students were basically given a slap on the wrist. Nothing happened to them, the football players. So she filed a lawsuit now. Could she have sued the football players for sexual assault? Of course she could have. Now, these guys had no money. They were never drafted. They didn't make the NFL. So, suing a couple college students won't get you much money. Instead, she sued Virginia Tech, the university. And she argued that they failed to protect her and from gender-based violence. Now, I mentioned this, I think, the first day of class, and when we did the 11th Amendment. You can't sue the state without its consent. You can't do it. Virginia Tech is a part of the state, the same way UT Austin or the University of Houston, right? These are state institutions. So you can't go to federal court and sue a state institution. You just can't do it without their consent. Unless Congress can waive a state's sovereign immunity. We'll do this later in the semester. We'll do Morrison again a second time, actually. But Morrison stands for the proposition that you can't suspend a state's sovereign immunity for combating gender violence. That is, Congress can't allow Virginia to be sued in federal court because it failed to protect Christy Brzonkola from gender violence. Okay? We're going to do that later. But the part here, can Congress create a can Congress create a cause of action for gender-based violence? Is that something Congress can reach under its commerce or necessary and proper powers? Right? Can Congress get after gender-based violence as a federal offense that you can sue in court over? That's the question here. Right? Everyone get the general gist of it, right? Okay. Okay, Ruben. So what's going on here?
I mean, it's not like a lot of facts, but it's just on the violence against women.
Is gender-motivated crimes of violence?
Congress wanted it to be because they said they would deter potential victims from going to that state and stuff, but the court found that they rejected that argument. They thought it wasn't, like, you can't, because it's like non-economic. So you can't.
Okay. Let's go down our list, right? Let's go back to our notes here from before. Okay. Is gender-based violence a channel of interstate commerce?
No.
Is it an instrumentality of interstate commerce?
No.
Okay, so in order for Congress to get at this, what must it be?
It has to do with, I guess, interstate commerce? Or
Yeah.
It has to be economic?
Has to be an economic activity, that's right. And Ruben, just finish it up. Is gender-based violence an economic activity?
No, they thought it was a state, like it's a state.
Okay, very good. That's right. So this case follows pretty directly from Lopez, right? It follows pretty directly from Lopez. Is possessing a gun in a school zone interstate an economic activity? No. Is an act of gender-based violence an economic activity? No, according to the court. Okay. Now, Damon, what about this line of reasoning, right? That if women don't feel safe, they won't be able to travel, and that has a substantial effect in interstate activity. Why is that sort of argument doesn't work here?
Because it's like that six standard of reasoning.
Yeah, what do we call that? What's that? What do we call that?
Inference game.
Yeah, I like the inference game, yeah. We pile inference upon inference upon inference, right? The court said we don't allow that. In Lopez, we're not going to allow it here. So even though gender-based violence might have some sort of effect, the act at issue here is not an economic activity. Now, that law, the Violence Against Women Act, has a difference from the Gun-Free School Zone Act, right? What's the biggest difference between the two statutes? The court notes this. So there's a big difference between the two statutes. There's a significant difference, at least. What did Joe Biden do with the VAWA that was not done with the Gun-Free School Zone Act?
honestly not sure right now.
All right, come back to later. Colby?
Didn't he describe in there, or like in there, that it dealt with interstate commerce?
Yes.
He said that in the.
Yeah, so here's the rub, right? In Lopez, they were lazy. They forgot to put findings of fact about how this activity relates to interstate commerce. They did it here. They made all these findings, right? But the court says the existence of findings is not sufficient by itself, right? Simply because Congress may conclude that an activity substantially affects interstate commerce does not make it so. So this even goes a little bit further than Lopez, right? And Lopez is like, well, make some findings, right? Here they made the findings, oh, that's not enough. So the dissent becomes very upset. It's like, look, come on, guys. You put forward a test. You said, if you do this, you'll be okay. And then they did it, and it wasn't okay. And I don't think the dissent is wrong. I think Lopez was here, and then Morrison were a little bit further out of what's required of Congress. So it's not enough to make findings. You have to make findings that are persuasive to the court. You have to persuade the court that there's an adequate fit, right? But here the court says this is not an economic activity. It's a local crime for the local jurisdiction to govern, for Virginia to regulate. And Congress cannot go after it. If Congress can regulate this, they can regulate murder, family law, and other areas of state regulation. So they said, we're going to draw the line. This is not permitted. And so the holding, right? Congress cannot regulate non-economic violent criminal conduct based solely on the aggregate effect on interstate commerce. I said it again. Congress can't regulate non-economic violent criminal conduct based on the conduct's aggregate effect on interstate commerce. Everyone with me? Okay, and the key point there is it's non-economic. And because it's non-economic, you don't get to aggregate, right? This will come up in a big way in the Obamacare decision. Is the choice not to buy insurance an economic activity? Is the choice not to buy insurance an economic activity? Well, the court says no. That not doing something is not an activity at all. That decision not to do something, you're outside the class of activities that Congress can regulate. You'll see next week, or next Tuesday. Jonathan?
I was going to say, isn't it specific to that industry that the larger the pool, the lower the rates?
Oh, that's what the dissent argues.
Is it by O'Connor?
No, she's actually not in the court anymore. She's actually, Justice O'Connor is not doing very well. She's probably pushing 90. She retired in 2006, in January, February 2006 from the court. So she's been off for a decade. Her health is failing, so think well of her. I know you're a fan. One of a few people don't actually like O'Connor, but she's there. She has good opinions every now and then. O'Connor was in dissent. She was not in the court. Her replacement, Justice Alito, was with the majority at that point. Okay, so I'm going to get Morrison, right? It's non-economic activity, and the findings are too imprecise. You can't regulate local activity in this fashion. Everyone with me? Morrison. Okay, so you had Lopez, it was 95 or 96. You have Morrison, it was in 2000. People's like, oh my God, the Supreme Court's going to start striking everything down. It's going to be like the New Deal again, right? It's going to be, switching times never happened. And then we get to Raich, right? Gonzales versus Raich, which, as I think you know, was argued by the co-author of your book, Randy Barnett, who's at Georgetown. There's a little picture of him from the Supreme Court. And it's pronounced Raich. Not Raich, but Raich, like R-A, Raich, okay? And this case involves medicinal marijuana. Now, the bottom line of this case is it's not 5-4, it's 6-3. So what happened? Scalia and Kennedy, Justice Scalia and Justice Kennedy, they were in the majority for Lopez and Morrison. They jumped over to Raich. Scalia and Kennedy, they struck down the laws of Lopez and Morrison, but in Raich they upheld the Controlled Substances Act. That's why the votes shifted. And if you want an easy way to remember it, Lopez, Morrison, Raich, they're in alphabetical order, right? Lopez came first, 95, then M, Morrison came 2000, then Raich, R, 2005. That's how I remember it, so it'll help you. Lopez, Morrison, Raich. So O'Connor, of course, dissented in this case, but she was only one of three. The dissents were O'Connor, Thomas, and the Chief Justice, Rehnquist. And this is noted in your book. By this point, Justice Rehnquist was basically on his last legs. He was very sick. He would die fairly short after. In fact, he wasn't even at the arguments. He was, he probably read the transcript at home, but at this point, he was pretty close to gone. Damon.
Didn't you just say that she was not in the previous court because she was retired?
This was her last year on the court. She retired shortly after this case was decided. This was decided in June of 2005. She was off the court, I think, by February of 2006. You can Google me on that one. But this was one of her last decisions.
But she was you just said that she was not in Morrison case.
No, she was, for Obamacare, for the Obamacare decision. For 2012, she was off the court. I think she retired January or February of 2006. You can quote me on the year, but I might be off by a month. But this was one of her last full decisions. What actually happened was, after the 2005 term, O'Connor was in good health, but her husband had Alzheimer's and dementia, and he was slowly disconnecting from society. So she basically retired to take care of him. It became really sad because his dementia advanced, he forgot who she was, which happens. My grandpa had the same. And basically he had to live in a home, so she retired from the court, but she was perfect health, but she couldn't really take care of him anymore, be with him. It was really sad. He actually started dating someone else in the home. It was, yeah. This is no. It does happen. They're perfectly healthy, but their minds, they just don't know who they are. And yeah, she was a remarkable person. She grew up in a ranch. Funny story. Chief Justice Rehnquist. Oh, you stole my story! Damn it. Chief Justice Rehnquist and O'Connor were in the same class at Stanford. And they actually dated briefly, not very long. But I think O'Connor, Rehnquist graduated first in his class, went to the Supreme Court. O'Connor graduated second in her class, couldn't get a job. She had people offering jobs as like a legal secretary. She had a good autobiography called The Lazy Bee Ranch. That's where she grew up. And she eventually made her way through Arizona government. She was elected as state court judge. And then when President Reagan came to office, he said, I'm going to appoint a woman to the Supreme Court, the first one. And they were searching far and wide. There weren't that many to pick from. And he picked O'Connor. He was very proud of that pick. She served in the court for 20-odd years, and then had stepped down for her husband. A remarkable person. She has been not in good health recently. I was actually with one of her former clerks yesterday, and he was saying that she's not doing too good. So, but she's Jonathan's a fan.
No, I was just reading about her on Wikipedia.
Oh God, Wikipedia. Did I say anything wrong? Is Wikipedia going to fact check me?
It's 2006.
Yeah, that's what I said, right? Okay, good. Was it January or February?
Doesn't say.
I think it's February.
I found one that said January 31st or something.
Oh my God, I'm really close. Yeah, I knew it was right at the cusp. The reason why I know that is because the day Justice Alito was confirmed, O'Connor stepped down. I knew he was confirmed in January, February. Yeah, that's one. So Raich, right? We've already covered this for the most part. Okay, so Cindy, want to give me the facts in Gonzalez versus Raich, please? That's right. Good. How come the state of California was in trouble by the use of marijuana, Cindy?
I think California allowed it.
Yeah. Right. So, by the way, everyone, this is a picture of Angel Raich. See what she's holding? Those of you not laughing, that's a marijuana pipe, hash pipe, if you will. Here's a picture of her in a hospital bed using a vaporizer. That's what that huge bag is. You can vaporize the marijuana. Here's Randy, my colleague, who argued the case for the Court of Appeals as well as the Supreme Court. In this picture, I always get sad. This was her finding out she lost the case. I'll pause here briefly. I may detain you a little bit after 2, but I'll try to be quick. you don't think about it when you're in the Supreme Court that you're reading about these cases, but there actually are people involved. And I always pay attention when the person goes to the Supreme Court and they watch their case being argued, right? And I often ask them, how did you feel? And they always say the same things, like, I realize how little I matter, right? But they also say the same thing, like, the justices don't care about me. They care about setting some broad legal precedent, right? Who cares about Alfonso Lopez, right? Who cares about Christine Gonzalez, or in this case, Angel Raich? But the justices are setting these broad facts, and this is why the facts of the case aren't issues very important. You have to finagle them. This was her when she found out that the case ruled against her. And the justices don't tell you in advance when they're going to rule. They just say, we're issuing opinions on so-and-so day. So you don't know what case it's going to be. You have no idea until you get a phone call. And usually they call you shortly thereafter to tell you. That was the facts there. So Monson was able to grow the marijuana. Raich was not. She had people who grew it for her and provided her with access to the weed. I love that it's Raich and Wickard. You have weed and wheat, right? Or I had a chapter called grain and ganja. I like that one even better. So under state law, it's permitted, but the feds, Gonzales, who's Gonzales, he was the Attorney General. The feds raided her, and Raich and Monson sued the Attorney General for violating her rights and for taking her pot plants. Okay, so the opinion here is by Justice Stevens. Stevens, as you recall, dissented in Lopez. He dissented in Morrison. Again, what changed? Kennedy and Scalia. Now, why did Scalia and Kennedy change? This is what law professors call the drug exception to the Commerce Clause. Justice Scalia perhaps couldn't stomach the idea of voting for pot growers. I don't know. I think he actually. I don't think that's the case. That's often what professors criticize him. And apparently, Justice Kennedy had someone very heavily involved in substance abuse in his family, and he perhaps had a sore spot for this topic. But the more interesting question, Anakari, how does Justice Stevens distinguish this from Lopez and Morrison, right? Why is this case different from Lopez and Morrison?
Well, in this case, Congress said that, the court said that Congress may regulate non-economic interstate activities. And in the other case, they say they could.
Okay, so I'm going to pinpoint one thing you said. Is the growing of marijuana in the backyard, right, is that an economic activity? Is it economic activity? You're right, it is. How does Justice Stevens know that growing of marijuana is an economic activity?
The Wickard case, the wheat was...
Very good. Very, very good. So let's go back to our list, right? Okay? Channels, instrumentalities, activity. What the court says here is that growing of wheat is an economic activity. Right? And he does this by citing Wickard, you're right. He also cites Webster's Third Dictionary, which drives Scalia batty. Justice Scalia hated Webster's Third Dictionary. He hated it. He loved Webster's Second. He said by the third edition they started making stuff up. He said in the third edition they said that imply and infer meant the same thing. It drove him crazy. In fact, in Scalia's portrait, which appears later in your book, he has a copy of Webster's Second Dictionary on the desk behind him. He actually wrote a letter to the New York Times, something complaining about Webster's Second. It was a big thing back in the 90s, but he hates Webster's Third. But under Justice Stevens' reading with Webster's Third Dictionary, economic activity refers to the creation, distribution, commodities, basically this broad definition, including every aspect of human conduct. Once you say that growing weed is an economic activity, Jeanette, what can you do? Right? Once you get to economic activity, what can you then do?
Ask whether it has substantial effect.
Yes, that's exactly right. That's exactly right. Okay? Once you have an economic activity, even if the activity itself is local, through necessary and proper, you can then go substantial effects. You can aggregate. That if everyone in California and Washington and Colorado grew their own locally grown marijuana, it would undercut the national scheme of drug enforcement, and you can't have that, right? So the key move that Justice Stevens makes is saying this is economic activity, Therefore, we have aggregation of substantial effects. Under necessary and proper, it's fine. In fact, I think Stevens is better on necessary and proper here than Lopez was. He actually talked at necessary and proper. Not as good as Scalia does a better job. But Stevens explains this. Okay? So the bottom line of the majority opinion Raich is because it's an economic activity, it's something that Congress can regulate through substantial effects. And he says this follows very closely from Wicker. Okay? This opinion also, I think, chips away at Lopez a bit. Because if growing, let me ask this question, Robert. If we take this definition of economic, or what is it? It's, I want to make sure I get the right one. Right? If we take this broad definition of economic activity, that's basically anything, would a possession of a gun have been an economic activity, Lopez? In other words, under Stevens' broad definition of economic activity, wouldn't possessing a gun have been economic activity?
No.
Why not?
Because there is no economic activity, there's no money trading hands.
Well, with the marijuana being grown, was any money being changed?
But that's something that's traded, so he wasn't selling.
No, there's no trade.
You can trade a gun, you can sell a gun.
No, one at a time, please, Robert. But there's no money being exchanged with the local growing
There's
open
a
passion.
market for marijuana, it's not the market for holding a gun.
Market for buying things? But what if with Diane Monson, she was just growing her own weed and smoking it? She never changed hands.
Right, but that's the same as in the Wicker case.
No.
The rule is there.
But just working on this, right? The court said that merely possessing a gun is not an economic activity. What about merely possessing marijuana that comes from the ground? Why is that not an economic? Well, why is the marijuana an economic activity but the gun is not? Dole, you seem to jump in there, so you want to try it? Why is possessing marijuana an economic activity, but possessing a gun not?
To me, I would say they're the same, but I know that doesn't answer your question. To me, I don't see the distinction.
You want to take it, John?
Because there are legal ways to get the gun, but there's no legal way to get marijuana.
Under state law, Texas could legalize carrying a gun in school. They didn't have to criminalize it.
It affects the sale of marijuana. It affects the marijuana market.
So does guns, right? If I have I don't know if Wikipedia is right, and he's bringing the gun to make the sale, right? If I'm buying a gun from some dude at school, I don't need to buy it from the store.
Was it because it wasn't a national thing trying to stop the trade of guns?
Is there not a federal national scheme to regulate firearms, Blair?
I think it's because marijuana has a high demand than gun possession.
Maybe, I don't know. You would?
Reason that it was like if they allowed everyone to grow their own pot, then there would be more of an incentive to have it and use it and sell it to other people across state lines. And so if they were going to allow that, it would set like, I don't know, maybe a possibility of that increasing and affecting their ability to regulate that illegal interstate trade.
So I have a perhaps more cynical answer. I think Chief Justice Rehnquist defined economic very narrowly in Lopez. And I think Justice Stevens defined it fairly broadly in Raich. And the effect of Raich was to get the courts very much out of the business of deciding what is and is not an economic activity. But, John, 1 second. But, and here's the big but, the regulation issue was still a class of activities, right? Growing weed, watering it, cultivating, these various activities. What happens if the thing that Congress wants to regulate is outside a class of activity? So shortly after Raich was decided, there was a law student, went to Case Western, not much older than all of you. And he wrote a student note for the law review. And, you know, people don't usually read these things, but he wrote it. And his article was about, could Congress regulate inactivity? That is, Raich said that Congress has very broad powers of regulating classes of activities. But what if Congress wants to regulate something outside that activity? In other words, to make you do something, to make you buy a product. That lawyer wrote this, his name was Robert Alt, I don't know. And no one really read it. And no one thought much of it. I didn't, but you know, most people didn't really read it. Until 2010, when the Affordable Care Act was being drafted. And this realization saying, look, the courts add the business of deciding what's economic, what's non-economic. That's Raich. But what if something is outside this class of activities? Can Congress regulate that? So his article predicted in many respects the Obamacare challenge that would come years later. This is why always you need to think and not just take gospel as what the justices say, because there's always, they don't anticipate everything their opinions always do. They can't always anticipate how you read things and how you can tweak language. Okay, so that's the majority. I'm going to do Scalia in a minute, but any questions in the majority? Yeah, Jonathan.
Is that what you meant by the drug exception clause to the Congress? Is that it falls outside what we're going to go?
No, I mean that Scalia doesn't like hippies.
But is that why they made this exception?
I don't think so, but people often accuse Kennedy of doing it that way. That might be right. But I think Scalia doesn't like hippies. No, but actually I think Scalia's opinion is the most coherent one in the entire lot. Let's do Scalia. We'll keep you limited after 2, I'm sorry. But I want to make sure we get this through. Right? Who am I up to? Stephen. So what's Scalia's point here? Scalia makes a he basically says, well, maybe I agree with the majority, maybe I don't. You know, he's basically saying, whatever, Stevens, it's on you, right? But what's Scalia saying here is a very, I think, important point, contribution to make.
He just said that the activity is subdivided.
What activity is subdivided?
As far as like the growing and like her using her own weed and everything that she was growing stuff. As far as like the Commerce Clause is necessary and proper, and it's like really broad.
Well, let me ask this question, Stephen. Does Scalia think that this activity by itself is an economic activity? No. He's a little bit fuzzy on that, right? A little bit fuzzy on that. But what does he think that growing this locally grown pot will do to Congress's nationwide war on drugs? What's the consequence of this locally grown marijuana?
He just said that it's impossible to distinguish the manufacturing and distributed interstate drugs.
Okay. Ambrose, what do you think? Why does Scalia think that this can be regulated by the federal government, even though it's locally grown and never crosses state lines?
Because it has to do with something that says that they're fungible commodities.
Okay. Okay, good. What's a fungible commodity?
I have no idea.
Oh, you gave me the right answer. Alex, what's a fungible commodity?
Yeah, I'm not sure.
What's fungible? Anyone? Right. So if I want marijuana, do I care if it came from Mexico, Nevada, or my backyard? Right. I'm not going to care. Well, maybe it's different varieties. I don't know. Randy and myself, we both never tried marijuana. It's true. Randy says I've never tried it, so I want to say I've never tried it. Maybe will at some point. But in theory, pot's fungible. Interstate. Okay. But Scalia's opinion, and this is where he quotes Lopez. He says, an activity can be regulated as an essential part of a large regulation of economic activity, in which the regulatory schemes can be undercut unless the interstate activity were regulated. In other words, the locally grown marijuana interferes with Congress's power over interstate commerce. What lets Congress get at this activity is the necessary and proper clause. Okay? And this is the key point. the regulation of an intrastate activity may be essential to a comprehensive regulation of interstate commerce, even though the intrastate activity itself does not substantially affect interstate commerce. Let me read that again for you. Scalia is not saying that the locally grown pot has a substantial effect on commerce. Just one joint, right? One pot plant. What he says is, you need to regulate this locally grown activity to make this comprehensive scheme work. Again, Scalia says, Congress can regulate even non-economic activity if it's part of a necessary part of a broader scheme. In other words, it doesn't matter here that growing marijuana is non-economic. It's irrelevant. If it's part of a broader scheme, then Congress can reach it. The relevant question is whether the means chosen, right, to ban local marijuana, is reasonably adapted to achieving legitimate ends. This is McCulloch v. Maryland. So let me summarize this for you. To Scalia, the locally grown marijuana is non-economic activity. It doesn't have to be. But Congress does have this nationwide drug scheme, the war on drugs, and growing local pot will undercut that marketplace. Therefore, Congress can reach it. Okay. This is not an application of substantial effects test. Just he's very careful in saying that. It's Congress has this nationwide scheme they have to manage. Now, on a preview for next week for Obamacare, the reason why the Affordable Care Act had a mandate to buy drugs, it's actually been repealed. It was repealed about 2 months ago. No one realized it. But the mandate was repealed about 2 months ago. The reason why Obamacare had a mandate was to put people into the insurance marketplace. The thinking was, if only sick people buy insurance, rates will go sky high. Probably not true, but that was the thinking. Can Congress make you buy a commercial product? Well, some said, look at Scalia. If you have this comprehensive regulation of insurance, right, to keep prices low, can't they make you go into the marketplace? Can't they make you go into the marketplace? The key to understanding the Obamacare decision is this. Even if it's necessary to make people go into the marketplace to keep the prices low, say it, Donnie.
Is it proper?
Yeah, you got it. It's not proper. Okay, and I'll leave you guys there, okay? That's what you keep in mind when you read the Obamacare decision. It can be necessary, but not necessarily proper. I'm going to have office hours after this. If you want to come see me, it's actually quiet today, please come on by. Thank you. And for those of you at home, the video will be online shortly.